Pilapil versus Ibay-Somera, GR number 80116, June 30, 1989. This is for criminal procedure, specifically on who may file crimes that cannot be prosecuted the official. Subtopic: Prosecution of the crimes of adultery and concubinage. Question: Who shall prosecute the crimes of adultery and concubinage? Answer: The crimes of adultery and concubinage shall not be prosecuted except upon a complaint filed by the offended spouse. The offended party cannot institute criminal prosecution without including the guilty parties if both are alive, nor in any case if the offended party has consented to the offense or pardoned the offenders. Question: Can the accused be prosecuted for the crime of adultery when she was already divorced by her foreign spouse? Answer: If the marriage does not exist anymore, as when the foreign husband has divorced the Filipino wife abroad, the complaining party could not be considered as an offended spouse. Hence, the complaint he filed must be dismissed. Facts of the case. This case was about the filing of a criminal action for adultery after obtaining a valid divorce decree. This was an original case for adultery filed by the private respondent against the petitioner Imelda Manalaysay Pilapil. The parties were married sometime in 1979 and got divorced in Germany sometime in 1986. More or less 5 months after the issuance of the divorce decree, the private respondent filed two complaints for adultery at the City Fiscal of Manila. Allegedly, while they were still married, the petitioner, Imelda Manalaysay Pilapil, had an affair with two different men. The respondent fiscal directed the filing of two complaints for adultery against the petitioner. The same were filed before the Regional Trial Court of Manila. The petitioner filed a petition for review to set aside and dismiss the cases against her before the Secretary of Justice. While awaiting the DOJ's resolution, the petitioner filed a motion to defer arraignment and to suspend further proceedings before the Regional Trial Court. However, Respondent Judge Corona Ibay-Somera only reset the date of the arraignment. The petitioner also filed a motion to quash on the ground of lack of jurisdiction, but the same was denied. On appeal before the Supreme Court, the petitioner argued that the trial court is without jurisdiction to try and decide the charge of adultery, which is a private offense that cannot be prosecuted de officio, because the purported complainant, the private respondent, a foreigner, and does not qualify as an offended spouse, having obtained a final divorce decree under his national law prior to his filing the criminal complaint. On the other hand, the private respondent maintained that he could not have brought the case before the decree of divorce for lack of knowledge. Issue: Whether the former husband may file a criminal action for adultery against his former wife. Ruling: No. The former husband may not file a criminal action for adultery against his former wife. The Supreme Court said that under Article 344 of the Revised Penal Code, The crime of adultery, among others, cannot be prosecuted except upon a sworn written complaint filed by the offended spouse. The law specifically provides that in prosecutions for adultery and concubinage, the person who can legally file the complaint should be the offended spouse and nobody else. In other words, only the offended spouse and no other is authorized by law to initiate the action, therefore. Corollary to such exclusive grant of power to the offended spouse to institute the action, it necessarily follows that such initiator must have the status, capacity, or legal representation to do so at the time of the filing of the criminal action. Hence, as cogently argued by the petitioner, Article 344 of the Revised Penal Code thus presupposes that the marital relationship is still subsisting at the time of the institution of the criminal action for adultery. In this case, the fact that the private respondent obtained a valid divorce in his country, the Federal Republic of Germany, is admitted. Said divorce and its legal effects may be recognized in the Philippines insofar as private respondent is concerned in view of the nationality principle in our civil law on the matter of status of persons. Private respondent, being no longer the husband of petitioner, had no legal standing to commence the adultery case under the imposture that he was the offended spouse at the time he filed suit. The allegation of private respondent that he could not have brought the case before the decree of divorce for lack of knowledge, even if true, was held as of no legal significance or consequence. The Supreme Court said that when the private respondent initiated the divorce proceeding, he obviously knew that there would no longer be a family nor marriage vows to protect once a dissolution of the marriage is decreed. Therefore, the former husband may not file a criminal action for adultery against his former wife. In applying the foregoing, the criminal case for adultery filed against petitioner Imelda Pilapil was dismissed for lack of jurisdiction.